Hi everyone, I'm Grove Southgate. It's another live event from MyData-TRUST. So some of you may have seen me speak earlier. I'm the DPO with MyData-TRUST. I'm also the Service Quality and Improvement Lead, but that doesn't really concern you today. And we're going to be discussing data breaches within the context of US clinical trials. So some of you might have been present for our previous events on how much would a data breach cost you. Spoiler alert, a lot of money. But today we're going to look at the two main regulations which might affect you if you're a US company thinking about doing clinical trials in the EU and the UK, or vice versa, a UK-EU company planning to conduct clinical trials in the US. So the US, we really need to think about HIPAA, and in the UK, the EU, we really need to think about GDPR. Jay.
So in the HIPAA world, we start with what's called individually identifiable health information. And this is information that's used to determine patient care, whether it's past, present, or future health or mental health services. And there are 18 specific identifiers of protected health information. Some are quite obvious, like names and social security numbers, addresses, but it also includes such things as medical record numbers, URLs, IP addresses, vehicle license plates numbers, full facial images. So when you combine IIHI in those 18 identifiers, we have what's called protected health information, or we hear the acronym a lot, PHI. Graham?
Oh, yes. On GDPR, the amount of data covered obviously goes way beyond health data itself. But obviously within the context of a clinical trial, the health data will be the most important data for you to think about. GDPR also concerns both electronic records and paper records when they're part of an organized filing system. Jay, can you confirm that HIPAA is only in respect of electronic records?
Actually, HIPAA compliance does pertain both to paper records and electronic health records.
Okay, that's good confirmation. Thanks very much, Jay. So, in the supervisory authorities, perhaps you go first, Jay, on this one.
Sure. So it's the U.S. Department of Health and Human Services, the Office for Civil Rights. Their acronym is OCR. They enforce HIPAA compliance throughout the entire United States. HIPAA can also be enforced by the Attorney General of each state. I've seen some Attorney General offices that have been fairly aggressive with HIPAA enforcement. Primarily New York, New Jersey are two that stand out the most. But again, the overall federal authority lies with HHS, the Office for Civil Rights.
Yeah. Okay, and it's quite different in GDPR because each member state of the EU and the UK, of course, now that it's left the EU, has data protection authorities. Some countries even have several data protection authorities per country, depending on their nature, and their behavior can be quite different. And also, similarly to what Jay just said, some data protection authorities are hotter on some topics than others, and CNIL, the French data protection authority, known to many of you, is very well known in terms of its concern about the processing of health data. And so, Jay, there's definition of a breach for HIPAA.
From the HIPAA perspective, we're going to get into the definition of a breach. It is the release of unsecured PHI or ePHI, again, electronic protected health information, to an unauthorized entity or an insecure environment, whether intentional or unintentional, and an impermissible use of disclosure under the privacy rule that compromises the security privacy of PHI. An impermissible use or disclosure of PHI is presumed to be a breach. We're going to define that in just a few minutes in terms of how you make that determination. But impermissible disclosures of PHI may be considered a reportable breach. Again, we're going to walk through how you make that determination in a few minutes. But disclosures can be accidental. They can be unintentional, such as faxing documents to a wrong fax number, even sending by mail, such as billing records, billing statements to the wrong individuals. And there have been a number of cases lately where, regrettably, providers have posted individuals' protected health information on social media. Also, utilizing a personal device to access PHI if that provider does not authorize workforce members to do so. So again, we're going to define how you make this determination in just a few minutes. Graham?
Thanks very much, Joe. I mean, the definition of a breach is somewhat different in GDPR. I mean, there are similarities, which you can see, but it's the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure or access to personal data. So it's broader. For me, HIPAA is mostly around unauthorized disclosure, so confidentiality, where in GDPR, it also goes to integrity and availability. So some of the cases are very similar. The accidental sending of records to the wrong recipient, hacking, the loss of paper archives in a fire, for instance, exfiltration of data by hackers, and these sorts of things. So the scope in GDPR is a bit bigger, but many of the actions you need to take when you discover a breach and analyze a breach are pretty much the same.
And Graham, let me just add too that going back to that previous slide, yeah, confidentiality, integrity, and availability also does apply to health records on the HIPAA side.
Okay. Okay. And do you think the authorities, supervisory authorities, are mostly focused on confidentiality, or they really look quite equally across the three areas?
I think they look at all three areas.
Okay. This is good to know. Here's what triggers the process.
So again, looking at HIPAA, a security incident means the attempted or successful unauthorized access, use, disclosure, modification, or destruction of information or interference within system operations and information system. Now that's exactly how it's defined in the code. A security incident should trigger the activation of an incident response plan, determine if the incident was in fact a breach of PHI or ePHI. The initial assessment will lead to a determination on whether the incident should be elevated to the level of a reportable breach. And regardless, you should always complete a security incident form and log it. It primarily stays an internal process unless there is an investigation by OCR. So again, in the HIPAA world, security incidents don't necessarily rise to the level of reportable breach, but as I mentioned, we're going to go through how you make that determination in a few minutes.
Yes, and looking at GDPR, there are some differences. I think actually we can think conceptually that in GDPR, a breach and all the actions that need to be taken are only start when we know there is a breach. However, I think it's extremely good practice to think of all security incidents, IT-based or otherwise, as being potential breaches and to report it, because otherwise you really don't get a sense as an organization of what your risk landscape is like. So I really like this aspect of the HIPAA regulation, that they really start early in the process and really start driving it. And I think it would be, even if you're not going to do HIPAA-based clinical trials, you know, I think it was really a good thing to take from HIPAA and really make sure that everybody reports potential breaches, even though perhaps later on we determine it's not a breach, and maybe not a reportable breach. But after that, the situation is pretty much the same. Now, we make an assessment of what type of breach it is, and we have a similar internal process, a data breach reporting form, which is monitored by and managed by the data protection officer most often within an organization. So here we see a great deal of similarity and lessons that we can learn from HIPAA for those of us who work in the GDPR world.
Okay, so now we're going to talk about how you make the determination. So remember, we kind of left this off. So unless the organization can demonstrate there's a low probability that the PHI has been compromised based on assessment of at least the following factors. I'll give you my commentary after we go through this list. So the 4 factors: nature and extent of the PHI involved, including the type of identifiers and likelihood of re-identification, the unauthorized person who used the PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed, and the extent to which the risk of the PHI has been mitigated. So in all circumstances, you must complete what's called a breach risk assessment to make a determination if notifications are required. And the results of this assessment process must also be documented. Now, let me give you some commentary. The reason I'm not a big fan of this, but this is, again, how the regulations make the determination, because it says if there's a low probability. So does that mean if it's less than 35%, that it's not a reportable breach, or if it's greater than 50? So when you go through this process, it's usually going to be dependent on the experience of your compliance officers and those that are going through the assessment process to make that determination. You know, my rule of thumb is simple. When in doubt, if you think there's a potential that any of the protected health information was compromised, then we're going to then make the report to OCR of the breach or do the breach notification. We're going to talk in a few minutes about the breach notification process.
Yeah. And in GDPR, there's some similarity in that we always complete a risk assessment to determine if notification to either the supervisory authorities or the data subjects themselves, the participants in the clinical trial, need to be made. The results of the assessment, very similar to the HIPAA regulation, must always be documented in some register of breaches, something you must keep to demonstrate that you're able to, in terms of the accountability principle of GDPR, that you're aware of your responsibilities and you take them seriously. Where it becomes complicated, and a bit like Jay's experience with HIPAA, is even in GDPR, there is no standardized mandatory methodology for conducting a risk assessment. This makes it can be extremely challenging, particularly for small organizations who are not used to making these sorts of assessments. I've mentioned the ENISA guide here, so there's a whole guide you can go to this guide and read it. There's a very detailed methodology. It may be overdoing it for some smaller companies, but I think it's a very good place to start with your risk assessment. And it's going to be highly determinant on what your next steps are going to be. Really, risk assessment for me, I've been involved in risk assessment of all different types for the last 40 years or so, and it becomes an art. There's a science to it, but there's also an art to it. There's seeing, you can apply some general rules and think of particular factors, but it's something that you will become better at over time. And so if you're not used to that sort of assessment, you should try and reach out to people who can help you. That could be your colleagues or other people in other companies that you know who may be able to help you, because getting this wrong can cause big issues for organizations. And that goes directly onto notification in GDPR. There are three things you need to think about. You always need to report the data breach in your internal register. That's what both Jay and I said earlier, and that's absolutely right for GDPR. Even for no risk or low risk data breaches. When it's a medium or high risk, you also need to report to the supervisory authority, which in this particular case, the rules have just changed around this, by the way. You need to report to every data protection authority where in a country where a data subject, one of your clinical trial participants, has been affected. In the past, up until about 6 months ago, you could just go to one main DPA, but now you must report to them all separately. And that number, 72 hours maximum, you have to be extremely careful about that within GDPR. I would actually say it's the thing that people don't understand. This does not mean that from the moment you as a sponsor of a clinical trial are notified of a data breach, you have up to 72 hours to respond or notify the DPA. You must notify within 72 hours, but in fact the regulation says you must notify as soon as possible. So that means you might need to notify without complete data because you may not have a complete picture of the breach at that particular point, but you can be fined just for late notification. And in the case of high risks to the data subjects, so your trial participants, you must notify them. And that's a particular problem for you as a sponsor, because you shouldn't know if you're doing some sort of pseudonymized trial with double blind, you don't have any means of notifying them directly yourself. So you're going to have to involve the clinical sites in this process. And so you need to make sure that you have good agreements with the clinical sites to make sure that they're aware of their responsibility and are able to complete and assist you in this, what is your obligation, because the obligation remains with the data controller.
Okay, let's look at the notification process under HIPAA. So let me just preface this with a couple things. When we're talking about doing the breach risk assessment, that is different than the required security risk assessment. And with HIPAA, the timeline, the clock starts ticking the date of discovery of the breach. So when we look at the requirements for notification in terms of the reference in the calendar days, it starts the date the breach was discovered. So there are two categories: breaches affecting 500 or more, and then fewer than 500. 500 or more is the big one. So in this case, you have 60 days to notify. It says the Secretary of HHS. It's technically OCR, but as the language in the code specifies, the Secretary. It says without reasonable delay, in no case later than 60 days. So technically you have 60 days from, again, the date that the breach was discovered. Individuals who are affected by the breach must be notified within 60 days. And there are parameters within the Code of Federation that specify what that notification must consist of. And it's typically first-class letter format, and that is sent out to the individuals. And it also requires a press release. And I believe the language in the regulations says it has to be to such as a notable media outlet. So not like a local newsletter. It would have to a prominent media outlet. So breaches affecting fewer than 500, there's two categories here. You have to also notify OCR, but the timeline changes. Technically, you have 60 days from the end of the calendar year. So hypothetically, if a breach is discovered, let's say you discovered a breach yesterday in your organization, and today is April 12th, 2023. Technically, you'd have until next March 1st of 2024 to make that notification. I always recommend when you figure out the who, what, why, how, when, and where, then submit the notification. And if you have smaller breaches that occur throughout the year, again, you have to submit separate breach notifications for each incident, but the same timeline applies. However, once you do discover the breach, the clock starts on that notification process again, typically first-class letter format. And as I mentioned, there are particulars what has to be contained in that notification letter to the individuals. But again, you have 60 days to notify the individuals for breaches that affect fewer than 500 individuals. Graham? And just so you know, in the US, this is open source. Breaches go on what's called the breach reporting tool, or what we call in the trade the wall of shame. And all breaches that affect 500 or more individuals are going onto this open source database for everyone to take a look at. Graham?
Yes, thanks, Jay, for that. In GDPR, there is no standardized reporting tool. As I said, each DPA, Data Processing Authority, has its own methods. They may have a tool. They may require an email, etc. I know I'm getting messages that we're overrunning a bit, so I'll go quickly through what is notified. The bit in red is what needs to go to the data subject. So the nature of the data breach, the contact details, where they can get more information, a description of the likely consequences of the personal data breach, a description of the measures taken to resolve or mitigate the data breach. And for data subjects only, and what's vitally important, because GDPR is there to protect data subjects primarily, is what actions can they take to protect themselves. And there are penalties, so they say.
Yes, there are. So again, I know we're short on time, but really it's based on a level of non-compliance. There's 4 tiers to the penalty process, and you can see here the ranges. And it also includes criminal penalties. I've seen a few of those lately. There's a couple cases out of Massachusetts and I believe Florida that didn't involve criminal penalties associated with HIPAA violations. Graham?
Yeah, thanks, Jay. I'm not going to go through this completely. I mean, the biggest data fine for a data breach was 101.5 million, as I think I said last time. But things that you need to be aware of, it's not just fines, it's not just the financial cost. You can be ordered to suspend the clinical trial or even to stop completely the clinical trial. So that's something that is going to, have a big impact on you. So always be aware it's not just financial, it's your business that's important. And Jay, the US is changing.
Yeah, just real quickly, just about every state now, I know this map was dated the 24th of March, but I believe every state now is moving towards some type of consumer data privacy protection laws. Some states like California are a lot more aggressive, especially on the enforcement side. But again, these consumer data privacy laws include, similar to GDPR, all types of consumer data, not just health information. So again, depending on states you operate in, you should be familiar with those state regulations. Graham?
Thanks, Jay. I'm not going to go into this a lot, how to prevent breaches, because this is all about security. We don't really have time now to go through it all now. What I would advise you, it's again, ENISA, the European Centre for Cybersecurity, because quite a lot of clinical trials are run by small and medium companies, and this guidance is directed at them, how to secure yourself when you're a small and medium company. I advise you to have a look at it, and perhaps in a future live event we might discuss it a little bit further. Conclusions, you can see there are some similarities, you can see that there are significant differences. What's important is you understand what your obligations under both regulations are, and other regulations in the states of the US, and make sure that all of your policies and procedures, they could be separate for GDPR, they could be separate for HIPAA, etc. But make sure that you cover all of the regulatory requirements. This is my conclusion. Would you agree, Jay?
Yeah, I would totally agree. So not knowing or size of the organization, if you're involved in a HIPAA compliance investigation, those two are not excuses that the government would accept. And I want to leave you with one stat, and it kind of pushes home that last slide that we just saw on cybersecurity, best practices and safeguards. According to OCR, the Office for Civil Rights, last year, 80% of breaches were caused by hacking and IT incidents. So it is incumbent on organizations to focus a lot on these cybersecurity safeguards. Conduct your risk assessments in both the gap analysis side and the risk assessments apply both to the HIPAA world and the GDPR world. That's how you're going to determine your vulnerabilities and threats. And if you don't have the internal resources, I strongly encourage to outsource that type of support so that your organization is sufficiently covered. And if you were the subject of an investigation, it's going to help your cause. Graham?
Yeah, I 100% agree. So we've come to the end of our content. We have overrun a little bit, but if there are any questions, we're happy to take them. I'll be reading them because I don't think Jay can see the chat at the moment, but and we'll see how it goes. So if there are any questions, please fire away. Question. In a clinical trial, how can you inform the participants as the sponsor shouldn't know who they are? Well, in GDPR, that's one of the things I mentioned, is that you need to have good contracts with your clinical sites to make sure that they're aware of their obligations to communicate data breaches on the behalf of the sponsor. Jay, do you have is there anything similar for a clinical trial sponsor trying to communicate with the participants when there's a data breach?
Yeah, I don't want to provide incorrect advice. So I would say that you'd have to look at the HIPAA privacy rule requirements. Mm-hmm. There are what's called citations, Code of Federal Regulations, that do pertain to research. So my advice is to look at what the regulations state and make sure that that is followed.
Okay. Any more questions? Oh, somebody's. So, people were saying whether the slides will be available for download. Sorry? Yeah. If you, sorry, I'm just having a technical problem. If you registered for this event, you'll be able to review the slides, and then we'll publish them on YouTube in a month or so. So if you want to see it again, and then you can see all the links. But but even if you can't see the links, you should be able to access some of the references that we gave you just by a simple search. Is there a recording of the last webinar? Yes, there is. It's now on MyData-TRUST YouTube site. You can see that. Any other questions? Sorry? An example of a data breach? Okay. To be honest, I mean, as Jay says, hacking is the biggest source of breaches. But in my experience, one of the ones that you see it's the biggest source of data breaches, which cost a lot of money, and they happen frequently. But just sending an email with the personal data that somebody's not entitled to receive would count as a data breach under both GDPR and, I believe, Jay, you can confirm that would be a data breach under HIPAA as well.
That it would be what we would call an impermissible disclosure.
Yeah. But yeah, any hacking of the data, in our case, any loss. So let's say you had a paper archive and it was destroyed by fire. That would be a data breach of a clinical trial because because you're obliged under the clinical trial regulations to keep the data in Europe for 25 years. And if you have a paper archive and you destroy it accidentally in a fire or in a natural disaster, then you are in a breach.
And Graham, let me just add too that ransomware attacks are considered HIPAA data breaches.
Yes, yeah, and in GDPR as well. And I've got one last question that I've got here is, in GDPR, is notification to the supervisory authority a one-shot activity? The answer is no. You make the initial notification as soon as possible, and then you may need to re-notify as you get more information, implement new mitigation actions and things like that. So you may have an ongoing conversation with the supervisory authorities as you deal with the data breach. And that's important to know. So you need to be on the ball and be ready to communicate with them at all times. Any more questions? I'm receiving a question live. Sorry, I'll just have to have a look at it. Yes. Yes, I'm being asked, is there any specific guidance on validating or verifying software when it comes to the protection of data? Personally, I mean, I can give you the negative guidance, which is do not download free software off the internet. Open source software is one of the biggest sources of vulnerabilities in software today. Something like 86% of all software from open sources has vulnerabilities included. So always, my approach, my personal approach is I always validate that I'm buying from a reputable company. I always do sort of due diligence, internet searches about security incidents based around the software, security guidance. There's always some good, this is not just the package that you're buying. There's always additional things you can do to make the product more secure. Always read that and see what you can do. I mean, this is what I would do. But avoid. I know there's a tendency to want to use free open source software, but personally, if you can avoid it, I wouldn't. And Jay, do you have some views on that?
I would concur. If it's free, it's not for me. And in most cases, you want to use some type of enterprise version, regrettably a paid version. So I think you're going to kind of save a few bucks here and there. It's probably going to cause you more aggravation in the long term than going with the paid enterprise versions of the software.
Indeed. Okay, Jay, thanks very much. I think we're coming to the end. So I hope that it was informative, and thanks, Jay, for taking part. If you have any further questions, you can contact us at our website, MyData-TRUST. We're easy to find, and we'll help you out as soon as we can. So thanks, everyone, for participating.